We need to bring that room side, okay? Okay, everybody, never mind us. How are y'all today? All right, good afternoon, everyone. Let me hit the record here. All right, thank you all for joining us for today's A Month of Service presentation of Legal Advanced Planning and Why You Need It. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Rachel Gutierrez. Also on behalf of our presenting partner with Lone Star Legal Aid, we have presenting today Ms. Jessie Campbell. But also included in the partnership, we have the Earl Carl Institute, Houston Bar Association, Texas Legal Services Center, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and the Houston Volunteer Lawyers. And together we make up A Month of Service. And basically what A Month of Service is the collaboration of all of our organizations. We come together on a monthly basis, offering a variety of different workshops, resources, and information relative to asset protection, asset building, community empowerment, and the maintaining of generational wealth. We started collaborating several years ago in an effort to reach more people, to create a larger impact, and get as much information out to the communities, considering we all have pretty much the same kind of mission and same goal and service the same communities. So we decided to come together and try to get as much information out to the communities as we possibly can. So that's how we kind of came up with the A Month of Service. So every single month, there's a variety of different workshops that we offer. And one of them, or the main one, being legal advanced planning and why do you need it? So Ms. Jessie's gonna be here today to tell you guys everything that kind of makes up an estate plan, kind of dispel some of the myths behind people actually creating wills and why they actually need one. So there's going to be a lot of information that's going to be covered here today. But do know that the information that is covered here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners should you find yourself in need of any civil legal assistance. So, and Ms. Campbell's gonna, go over your, the information about how to contact their office and the other services that they offer as well. So with that being said, this is your opportunity to ask questions at the end of the presentation that you like. If you're joining us on Zoom, please feel free to type your question into the chat. Please keep in mind that we are broadcasting live. We're now live on our social media platforms, including YouTube, and it will be linked to be broadcast on Facebook as well. So as you're asking your questions, we want to try to protect your privacy as much as we possibly can. So we ask that you keep your questions to be general in nature, to not divulge any personal detailed information about your individual situation. But again, we do encourage you to reach out to the legal service partners to apply for their service. Do not assume that you will not qualify for their services. They do provide service on an income basis, but again, do not automatically assume that you will not qualify. So please make sure that you reach out to them as well. With that being said, we're going to go ahead and get started. Again, there's a lot of information that we got to cover here today, and we hope that you all receive the information that you came here to get today. So with that being said, we're going to go ahead with the introductions and move right on into the presentation. So Rachel.
Hello, everyone. My name is Rachel Gutierrez. I am a community outreach coordinator for the Department of Neighborhoods, Office of Neighborhood Engagement. I, along with my colleague who is a new coordinator with our department, Cecile Carlson, welcome you to the Month of Service program on behalf of Mayor Whitmire and our director, Director Sims. We thank you for your participation and engagement in the program. We know that it's important to educate and empower the community about different aspects of their life, one being generational wealth. So we encourage you guys to take the information that you learned today and not only apply it in your life, but those that are around you. Inform your neighbors, your family members, your loved ones of the opportunity of protecting what's most important to them, their assets, their property, anything that they might not think that it's important, it is important. So making sure it goes to the people that they want to see it go to, rather than having somebody else dictate and going through the trouble with the courts and lawyers and fees for them to be able to receive your hard-earned work. So today's workshop is it's crucial, it's very important. But also the other workshops that we offer on a monthly basis are just as important as well. So we encourage the engagement on a monthly basis. Tell your friends, tell your neighbors about the workshops. We post that information on a monthly basis on our websites, so you know what type of workshops are being offered. If there's not a current workshop that we offer and that you would like to see happen, feel free to email myself or Nia about the topic of the workshop, and we'll see what we can do as far as having that information available for you. But thank you once again for tuning in. We appreciate those that have been loyal to the program, and we hope to see new participants as well. So without further ado, I'll go ahead and let our presenter start. There's a lot of information, so we want to make sure we get that information in. So thank you and enjoy.
All right, Juicy, you're up.
Good afternoon, everyone. Thank you so much for coming, for those of you who are online and for those of you who are here visiting us in person. This is my first time coming back to a hybrid one, but I understand it's our second one, and in terms of returning back to in-person recording his stuff. Okay, recording back. All right. So welcome everybody, and thank you so much. This is also going to be the first time that we are shifting back to the way before COVID we used to do our legal advanced planning trainings in two parts. The first one has an introduction as to what is legal advanced planning and why you need it. And then there was a second part, which is to kind of provide legal instruction, not advice, but information about how to draft your own documents for many individuals who may not qualify for legal services, but still are in that in-between and cannot afford to hire an attorney. And so we wanted to be sure that we were serving that client base, or that population who needed to learn how to draft their own documents. But even if you do qualify for services or can hire an attorney, by going through this process, you'll have a better understanding of what you need to know, what a will looks like, and what needs to be included in that. So today is that part two. We're going to be talking about how to draft your own advanced planning documents today. And if you did miss our first part, which is the introduction, which kind of talks about the big picture, why you need advanced planning, what each document actually does, we do encourage you to go watch the recording for the August presentation that is available on YouTube, and that information will get sent via email, but you can find it pretty easily, as well as via our Facebook page. And so take a look at that, because you really should look at those together. But if not, we'll be here next month doing the same thing next month with the introduction. All right, with that, let's get going. All right. So first, let me tell you a little bit about Lone Star Legal Aid. That is who I am with. My name is Jessie Campbell, by the way, supervising attorney with Lone Star Legal Aid. And we are a civil legal aid organization. And so what that means is that we provide free legal services to households that are eligible, that are qualified, that is based on the size of the household and the income and the assets that that household has. And that is how we determine eligibility. And we do civil legal services, which is not everything, but many things that are not criminal and not driver's license, like traffic tickets and that type of stuff. But examples are consumer, employment, family, healthcare, housing, landlord-tenant, juvenile issues, neighborhood problems, public education, benefits, estate planning, probate, and that's just a sample of what we do. We serve 72 counties in the Eastern and Gulf Coast regions of the state of Texas, as well as 4 counties in Southwest Arkansas. So basically, it's the eastern third of the state of Texas. I always kind of we have 14 offices. In addition to Houston, we have 13, and those are listed. the idea behind it is that if you ever know anyone who lives in the area and they need civil legal services, we are available to help. We also say, don't assume that you may not qualify for services. The number fluctuates quite a bit in general, but the estimates are between 30 and 40% of the state of Texas may qualify for legal aid services. So don't count yourself out, because you may qualify. And if you need it. All right. So again, just to reiterate, today is for educational purposes only. Nothing I say today should substitute for legal advice. If you have any particular question about a personal situation, a personal need, we do recommend that you speak to an attorney about that particular issue. Okay. So what is our agenda? So today we're going to be talking about just a little small bit of introduction, which is talking about how to choose a representative, because that's really important when you're drafting your documents. Then we're going to talk about how to draft a will, like what are the types of wills that exist. Does using the pro se forms, pro se means self-representing, doing things by yourself on a legal matter. Do these forms work in your situation? And then we're going to walk through the pro se forms. But remember, again, just because the pro se forms do not apply to you and you might like, nope, that's not going to work for me, I need to hire somebody to draft me something specific, this presentation is still going to be helpful, because it's going to talk about the different parts of a will. And so then you'll understand what those different parts mean. We're going to talk about a transfer on death deed as at the very end, which is having to do with land and real and houses. And then we're going to very briefly talk about planning for incapacity. This is the first time I'm doing this presentation, so I'm very much focusing on how to draft a will, how to transfer on death deed. We will not be talking about specifically on the planning for incapacity, other than to just tell you a little bit more about that. And, so just so that you're aware of that. So as you see from the agenda, what we will not be talking about today is probate. And so sometimes people come to this presentation because they think it's the same topic, and it's not. Estate planning, advanced planning, is preparing. It's planning for someone's passing, and it's planning for potential incapacity in life. Whereas probate is after someone has already passed away, someone has become permanently incapacitated, and now we have to look at a guardianship. So they are the opposite side of the same coin. We will not be talking about probate. So just so that if you're aware, if you are here because someone has passed and you're trying to figure out how to clear title or how to deal with the estate, that's not going to be today. That's going to be in another presentation. I don't have the exact dates, but you'll get the email with the dates, where we will talk about how to clear title and probate questions. I'm sorry, what was the date? Sorry, I thought you were telling me the date. Okay, so be sure you can go watch that one. So think of our presentations as a three-parter, as you would say. All right. So let's talk about choosing your representative. Each document is going to have a different name. In a will, that's your executor. So that's what it's called. But a power of attorney, it's your power of attorney, it's your agent. So it does kind of depend on what the document is, but ultimately they're all the same kind of idea. This is a person that you are picking to step into your shoes, to handle your affairs when you are unable to do so, either due to your own passing or to your incapacity, with the inability to make decisions for yourself. And so that's what it is. So when selecting someone, you should select someone you know and trust, and that who will do what's in your best interest, or as you would do it if you were able to make that decision and do what you need to do. So that's the type of role that we're talking about. It's a little different from a person who wants to do what is best for you, if that makes sense, right? So sometimes it's a loving decision, but what that person would want to do for you is not what you would do for yourself, right? And so, and not, that's not disparaging, right? That it's love, right? It's a difference of opinion on what the next step should be. You want to pick somebody who will be able to step in and do as it is that you would do, because that's what they are. They're kind of basically representing you. And so be aware of that. You should select one person. Sometimes there's an option to select co-person, co-executor, co-agents, etc. Sometimes you cannot. The law will not allow it. Will not allow a representative or co-agent in the situation. But as a general rule, even if the law does allow a co-representatives to step into the role, I generally advise against it. And the reason why is because one of the reasons why you do advanced planning is to ensure that you avoid conflict, you avoid having expensive court proceedings and down the line. And so when you have two people who have the same powers and the same authority, then there's conflict. What you're trying to avoid doesn't really get avoided. Now you're going to end up with a situation where then who's the person who makes the final decision when there's conflict, when two people have the exact same level of authority. So we generally recommend against it. If you feel like you need representatives in any kind of situation, I do recommend you speak to an attorney about that. So that way we can kind of make sure that your needs are being met in that situation. So that way we can avoid those potential conflicts. Think of it this way. I was in a training, and the way that the instructor kind of described it was like, do you really want two people driving a car? And that's really what it is, right? And who's going to be distracted? Who's going to make the turn signals? So discuss the decision with the person. Be sure they understand that you've selected it. Don't let it be a surprise. Be surprising how many people it is a surprise. Don't let it be a surprise for them. The one they need to be prepared for, because they need to know that they need to go do something if they are the person that's responsible. Discuss what you would do. Have hypothetical conversations with them. If they're your executor, talk about what's in the will. Explain the will to them. It's like, look, when I say grandma's diamond ring, you know the diamond ring, the one that's been passed down from mother to granddaughter, like that ring. That's the ring I'm talking about. I'm not talking about the diamond ring that she bought when she was, celebrating her 65th birthday. That's this ring, right? Like, explain things so that way the executor understands what decisions that you have made, because they're going to be the ones who are going to be doing the work. They're going to be the ones that's going to make sure that grandma's diamond ring goes to the right person, and that the second diamond ring goes to the correct person. So be sure that they understand that. Same thing of talking about the medical side of things when you're planning for incapacity. Explain things. And sometimes this is hard, by the way, right? Like, this is the counselor side of things. That can be a difficult conversation to have with people, because you're likely picking somebody who loves you, right? Like, and who wants the best for you and wants you to be around as long as you possibly can. And you might be having these difficult conversations about, what decisions you would make in the event of a permanent incapacity, and there's a likelihood of no recovery. And so we're now talking about what type of end-of-life decision-making you would want to have. And that can be difficult. Those are difficult conversations, but it's empowering to the person that you're going to be having that conversation with. So that way, one, they understand what you would do, the types of scenarios that you were thinking about. And then that way, when it, let's hope it doesn't happen, but if they are put into that situation where they have to kind of move forward and make those types of medical decisions, they'll know what you would want to do in those situations. In every situation, you want to be sure you have an alternate. If your first choice is unable to serve, you want to be sure you have a second or possibly a third alternate that can step into the role. Have similar types of conversations with those individuals. The other thing that's kind of on the counseling side of things, it's not always going to be who you think it's going to be. I'm going to tell you a little bit about the probate process. It's work. Like, it's not like it's work. It's generally about 9 months to a year, typically, of an executor doing a lot of paperwork. And that's the executor. That's not the attorney doing the work, although you can hire an attorney to help do some of that. A lot of it falls on the executor, and it's things like contacting creditors and being like, hey, person has passed away. This is what we can afford to pay you. This is what we can't afford to pay you. It's selling the house if the house needs to get sold. It's taking care of business, right? That's really what it is. And so you want to pick a person who can do that, right? And it's not always going to be your oldest child, right? Like, it might not be. And so I use my family a lot as kind of a joke. And although some of it's true, some of it's not.
like, I'm the executor on my mom's will. And, but I'm the baby, I'm the youngest child. And so I always joke with my brothers, it's because I'm the favorite, but it really isn't. My mom basically always reminds everyone, it's like, look, this is a lot of work. This is paperwork. There's a lot of stuff that needs to be done. Let the lawyer take care of that. The lawyer knows what to do. It's going to be easy for her. Let her take care of it. You non-lawyers, you know, maybe not so much, right? And so, but we know it's because I'm the favorite. But but sometimes it is picking the right person, right? Like, because of the nature of what needs to be done. Because again, these are people who love you, they may be grieving, and they may not necessarily want to be in a situation. You may realize that they may not be emotionally in the right place to be able to handle that type of work. But that being said, if you do pick somebody who's not the natural choice, your oldest child, or if you're like me, I always think I'm in charge of everything, right? It's not the one who's taken on the mantle of being the matriarch of the family, like whatever it is, right? There's someone who thinks it's going to be them. Have that conversation with them too on why they were not picked. It's a loving decision. Look, you're going to be sad. You know, we have dinner every day. I talk to you on the phone every single day. Do you really want to be having to work with a lawyer and writing a deed? Do you really want to be working like let Uncle Bob take care of it? Uncle Bob will be sad too, but he's an accountant. He'll be fine, right? And he's not going to do anything without talking to you and making sure that the family's okay and things like that, because I trust him, because that's who he is. He'll do the paperwork, but he'll make sure that the family's interests are protected because he knows what I want. So have those conversations. All right, so now we're going to start getting into the meat of the last will and testament. For those people who are here in person, we have samples of the documents that you can follow along with. We've given you what you've asked for that may represent your family in your situation. But that being said, I'm going to be talking about both documents as we go, so just be aware of that. So sometimes you may be like, mine doesn't look like that, because it's going to look different depending on whether you're married with children or with or without children, or single with or without children. So they are going to be different documents. All right. So for those of you who are online, the website will show up in a minute, but the link will get emailed to you so you can take a look at that at a later time. And you can always come back to the recording and follow along on the recording when you're working on your documents at a later time. So remember that. So what does a will cover? So what's included in a will? What the court will have jurisdiction over, have power over, to be able to do what they need to do with the property. So that's what so you have to know what that covers. To do that, we kind of go backwards. We talk about what a will doesn't cover, because remember, a probate process is the process afterwards. It's the court process where we're going to deal with the property and the debts and that type of stuff. So when we're looking at it, we look at what is not going to be under that court's jurisdiction. And those are known as non-probate assets. They're already owned in such a way that the property will pass upon death according to the terms that have been agreed upon. So those are your retirement accounts, IRAs, 401ks, 403bs, whatever type of retirement account that you have, financial accounts. So Schwab, Mutual of America. I don't know all the companies, but like those types of things, right? Life insurance proceeds, payable on death accounts. Payable on death accounts are going to be like your checking accounts and your saving accounts. Those are going to be at your bank, your banks. You can change your accounts. If you don't already have it, I'm going to let you know this is a thing you should consider doing. One of the biggest reasons why some people come to us needing a probate, that the only thing that they need to go to probate court for and hire an attorney and do a probate process is to get access to a bank account. And that is it. There are lots of solutions to be able to avoid that. One, you can create a joint account where someone is already a co-owner on the account. Generally, I don't recommend that. It's your money unless you really want to add somebody to it for other reasons, for different reasons. Their person is helping you already manage your finances, and giving them access to ownership of the account makes it easier, that type of thing. Like have a different reason other than inheritance, right? To add somebody. So that's the first one. You can create a joint owner, but typically I don't think you need to do that, because you can do what is known as the payable on death account. And that is saying to your bank, hey, this is my checking account. I own it. It's my money. It's my checking account. The person doesn't have ownership of it until I pass away. And then you're going to name a beneficiary on a payable on death account. And then when the person passes away, then whoever is the beneficiary will go to the financial institution, say, and offer a copy of the death certificate, whatever application or documents that financial institution asks you to complete, and then that check or savings account will then get transferred to the new owner, the beneficiary listed on the account. So that's one way to handle your bank accounts. If you take care of that, you may be able to avoid the probate process. If that's your biggest aspect of property that will need to go through probate. Now, of course, we're going to be talking about a will, so in anticipation of going through a probate process, but that's something to consider. There's also joint tenancy with a right of survivorship. This one's a little different. Retirement accounts, life insurance proceeds, payable on death accounts. You name a beneficiary, right? You're going to complete the form with the financial institution. A joint tenancy with a right of survivorship is when you are joint owners, and then the survivor will be the one who inherits the property when one passes first. This is really important to know in the state of Texas. Joint tenancy with a right of survivorship is not standard. The standard co-ownership is joint tenancy without a right of survivorship. So if you own property with somebody else, for example, community property, you and your spouse have purchased a home, you own that property as community property, your spouse is not necessarily the heir of the property if you were to pass first, and vice versa. If your spouse passes first, you may not necessarily be the heir of that property. It has a lot to do with your family dynamics and whether or not there's children from a previous relationship. Sometimes that is the heir, sometimes it's not. And so your half of your property, or the percentage of the property that you own, passes according to your will. So if you own 50%, 50% is what gets passed according to your will or inheritance laws, and the 50% owned by the other person passes according to their will and their inheritance laws. So that's the normal way. That's the standard way that property is owned in the state of Texas. So if you want this joint tenancy with a right of survivorship, where the co-owner automatically becomes the owner of the entire property upon the passing of one, you must create a joint tenancy with a right of survivorship. So, but that is an option. I do recommend that if you're thinking about doing that with any property, that you do consider seeking an attorney to kind of talk about it. It's very hard to undo once it's done, and there can be unintended consequences that people might not be thinking about. And so just talking to somebody, talk it all the way through to be sure that really is the right path forward for you. Okay, so that means everything else is a probate asset. Anything else is going to be covered under the will. But if you don't have, so that's it. Anything not listed, right? Now, that being said, a non-probate asset can become a probate asset if you don't have a beneficiary named. And so be sure that these accounts have beneficiaries named, because again, if it's silent and there's like a life insurance proceed and no beneficiary named, then that now becomes a probate asset. And now that has to go through the probate court. And just real quickly, like what the impact of that is. Say a person has a life insurance policy for $50,000, right? And so if you have a beneficiary, you just send in the death certificate, whatever paperwork that life insurance company requires. Beneficiary / beneficiary, however it is, it's going to get a check for $50,000. That's how life insurance works, right? Now, if you don't have a beneficiary listed, but then you have a will, now you got to hire a lawyer, because you can't go to probate court without a lawyer. So now you got to hire a lawyer. And so the lawyer is now going to take your will, go to probate court. And that lawyer, let's just say, is really inexpensive, and it costs $1,000, right? That's an inexpensive lawyer, by the way. That no probate's happening for $1,000. But it's $1,000. Well, now, after you do that, you got to pay filing fees. So let's just round that up, that the whole probate is going to end up costing $2,500. Well, now your beneficiary is only going to get $47,500, right? Well, they lost $2,500. Now, what happens if you don't have a will? Now you have to hire a lawyer, and now you need to go into court. All sorts of things can happen there. Like all sorts of things. You can have, the court can be like, sure, we agree with you. These are the heirs. It's still going to cost you $2,500. Fine. Right. It also could be that the court might be like, no, we don't know. We don't know. This is the only heirs. We need to do some research. We need to hire an attorney to represent the unknown heirs. And that can be lengthy. That can be expensive. That can cost another $10,000. And so now we have without a will, let's say that attorney doing that work is going to cost $5,000. And now you have court doing its own thing with another expensive $10,000, right? So what was supposed to be a $50,000 beneficiary is now $35,000.
right? So I'm just putting that, make sure you got beneficiaries on all their non-probate assets. But either way, you're going to want to have a will, right? So be sure you have that. But no matter what, I'm going to let you know, don't be scared of the probate process, even though I just put the fear of the probate process into you. In Texas, it's one of the easiest processes that you can have. If you're going to encounter the court, probate in Texas is not bad if you have a well-drafted and properly executed will. Other states, you may hear about the probate process being complicated in other states and expensive, really expensive, like tens of thousands of dollars in other states. That's not the case here in Texas. Even with a complicated estate, a well-drafted will can still make it really pretty effective, and you can move through it pretty quickly. And so we're going to talk a little bit about how that works when we get into the will itself, but I'm going to let you know, it's better to have a will and not have it, as I use in my life insurance example, right? Like, you know, you didn't name a beneficiary, but the will came in, it cost $2,500 total. Most of the money still went to the beneficiary. Not having that attorney is what caused the court expenses to go all the way up. So sometimes you just don't know. I have had clients come where they thought they had planned for everything. They didn't need a will, so they didn't draft a will. And then, believe it or not, a random life insurance policy shows up. Unclaimed property. Unclaimed property. If no one's checking that website, you should do it. I did that a couple of weeks ago and found $3,000 for my brother. Like, he actually still has no idea where that came from. Like, he's like, I don't know where that money is, but he claimed it. He got his check. But it was, but unclaimed property. If you find unclaimed property for a loved one that's passed, you have to have a probate in order to claim that property. So it's, you know, it's like these things pop up. And so it's the, so it's better to have that will and not need it, right? But then if you need it, it makes you all of a sudden you need it and you don't have it, it can be a big difference. So no matter what I say, you still should have a will. All right. 2 types of will. Holographic will, this is 100% in your own handwriting, cannot be delegated. You cannot instruct a person on the side to write the will for you in their own handwriting. A handwritten will must be in your own handwriting, okay? That's it, sign and dated, 100% in your own handwriting, sign and dated, that's a valid will in the state of Texas. Okay, there's no other requirements in that. I get questions about, like, do you need to put in an envelope, mail it to yourself? Nope. You just need to write it in your own handwriting, sign and date it. It's optional to have 2 witnesses over the age of 14. And it's also optional to have a self-proving affidavit. We'll talk more about how to execute these wills. Again, it's part of the will, so I'll get to those particular parts. Yes, ma'am.
When you have a handwritten will, do it have to be notarized?
No, wills actually, neither will has to be notarized. The self-proving affidavit, we'll get to that part when I talk about the specific parts of the will. Okay, so I'll get back to that, I promise. Okay, so an attested will is a typed will, 100% typed. So take out your computer, you take out your typewriter, you're so inclined, click-clack, type it up, print it, and that's a typed will. That cannot be a hybrid will, no fill in the blank wills, which is why, for those of you who are in the room with me, all of the sample wills that we gave you have a big old red draft written on them, because we don't want you to accidentally do it as a fill in the blank will and assume that your will is valid. In the state of Texas, it has to be one or the other, 100% in your handwriting or 100% typed. It cannot be a combination of either. And if it is some form of a fill in the blank will, the court is only supposed to look at the parts that's handwritten, which I'm going to break the news to you, usually doesn't show will. Like it's hard to make it into a valid will at that point in time because it's only looking at the parts that's handwritten. So, so just be aware of that. So for those of you, because again, we're about to talk about a fill in the blank will. It cannot be fill in the blank. You need to go to the website. You can download it, type in the blanks, and then print a printed with everything typed in. So I'm gonna probably say that more than once again, but then you're gonna sign and date it. For a typed will, you must have 2 credible witnesses over the age of 14. In the witnesses, they have to be disinterested. We'll talk about that again, but just to let you know, that means someone who doesn't benefit under the will, either has a beneficiary, has a creditor in any form, shape, or fashion. Those are what's considered a disinterested witness for the will. And again, over 14. All the other documents that I'm going to talk about later that require witnesses require them to be over 18 years old. Only the will allows them to be over 14. So, so Jenna and I always say, try to find two 18-year-olds or older, because then they can witness all your documents, not just your will. In both of these documents, we have what is known as a self-proving affidavit. That's optional, but highly recommended if you can do that. That is where the notary comes in. Again, when we go through each step of the will process, I'm going to talk a little bit more about that self-proving affidavit. But the self-proving affidavit, what that allows is that it eliminates the need for a witness. So when you go to probate court, you take the will to the judge, Your Honor. There is a copy of the will. Fantastic. If it's 100% in someone's handwriting, the court's going to require two witnesses who can testify to the handwriting. That's important. Who knows your handwriting? So that's not interested. Disinterested witnesses who know the person's handwriting testify, yep, that's that person's handwriting. Fantastic. All right. So if you have witnesses that witness the will, then what happens is that, Your Honor, here is a witness will. I have a will with two witnesses attached to it. Fantastic. That's great. I need one of these people to come to court to testify. Yep, I watched that will. I saw that it's a valid will. And then that's great. Fantastic. All right. So that's the normal probate process. What a self-proving affidavit does is that you now execute your will in front of a notary. Notary will notarize the will. And then what happens is that, Your Honor, I am providing you a self-proved will. And Your Honor's gonna be like, fantastic, looks great, all the requirements are there. No witnesses required, enter, let's, swear in the executor. So if you are able to do a self-proved will, we do recommend it. Again, I'll talk more about it when we get to that section, but that's just the overview at this point in time. Okay. All right, so here's the pro se form. So again, pro se is self-representing, doing things by yourself, and not an attorney coming in and doing it for you. That's the website. It's also in the chat for those of you who think it's in the chat. Yes. Oh, okay. Who are online. But the forms, there are 4 types of forms. As I said, married or single, widowed, or divorced, with or without children. That's basically it. There's also bilingual Spanish and English forms available on the site as well for each of these forms. You don't have to use the bilingual form if not, but if you don't, but you could if you wanted. But they are available. All right. So now here's the question that usually people will ask. I've gotten asked when these first got released earlier in the year, and people were like, oh, Jesse, do you recommend these? And I was like, oh, and I go, oh, maybe. And the reason why it's a maybe is because these forms are not for everybody. It's not going to necessarily be good for you. If they do meet your needs, fantastic. The forms are great. They meet all the requirements of a will. You're going to see that as we go over it. But your estate planning, your advanced planning is yours. It's individual. It's going to depend on a lot of factors that you have to take into account when you're doing your will. And so sometimes these forms will not work for you, and you do need to speak with an attorney to be sure that those things are being met. So what are those types of things? Family members and dynamics. Unfortunately, not all families are happy families. It's just unfortunate, right? There's estrangements, disownments, that can potentially happen. People have adopted families, right? Because of that, where there might not be a legal relationship, but there is most definitely an emotional one where it's like, you can joke, it's like my brother of another mother type of thing, right? But it's true, right? I have friends that are sisters to me, like 30 years of friendship that I would consider without a doubt a sister. And so it's so people have different dynamics that come into play, and that's something they're going to take into account. That again, some of these forms are not going to look at. They're not going to be able to address. The type of property that you own, where is that property? Do you own it solely 100% in your own? Is it separate property, community property? So the type of property and what you want to happen to your property is going to make a difference on whether or not the will is going to be the right thing, that these forms are going to be the right thing. These pro se forms assume a standard nuclear family structure. So if you don't have with standard property ownership, what you would expect. Most people are either married or single, with or without children. They may or may not own a house. They may or may not own a car with household goods. And that is pretty much it, right? They're not going to take into account nuance. They're not going to take into account those types of things. So again, as we go through it, you need to ask yourself, can I accomplish what I want to happen with my property using this type of form? And if you're not sure, seek an attorney's counsel. All right, so the other thing you have to think about is who is inheriting. Do they have special needs to be taken into consideration? This is not the only factors, but these are definitely things to be thinking about. People who are living with a disability and receiving government benefits based on income, inheritances can make them unqualified for those government benefits because now there's income. Now that person has received something that can potentially cover their necessary living expenses. The issue is that it's pretty rare that a person's inheritance can completely replace the living expenses that the supplemental income is providing to the person living with a disability. So we need to protect the benefits that are coming in, right? So we want to be sure that this individual doesn't outright get the funds. So that way we can protect those benefits, may or may not, like depending on the situation. Is the person under a guardianship? Sometimes people, even though a person is permanently incapacitated under a guardianship, you still want them to be the ones who inherit the property. Now that property is going to be under the guardianship of a person, of the estate. Someone else is going to be managing it. Do we need to think about that? Minors under the age of 18, we have to think about what happens to them and their property if they're the ones inheriting. So these are, again, just kind of factors to take into account, not the only ones, but who's inheriting and what we need to be thinking about for those individuals. Debt owed. Hate to break the news to everybody, but debt survives passing. It is a misconception that goes away, and it does not. Secured debt survives for sure. The property that secured is like your car loan, mortgages, those survive. They're inherited subject to that property is inherited subject to that debt. And so the heirs need to be aware that they're going to have to pay that debt off, and if they're going to keep the property, or they need to sell the property in order to pay off that mortgage. Credit card debts also survive. They are handled differently than secured debt, but you still need to be aware that the debt may survive. And sometimes what's going on with the debt and what you need to do to take care of the debt will inform how you want to write your documents. Some of it goes a little outside the scope. It's just more for you to think about it. Like, think about like, what's going on? What do I need to think about, like in that respects? Special instructions for heirs. You're going to see in these documents that there's no place for special instructions, and people do have them. A very common special instruction. There's kind of two that I use as examples that I see a lot my clients request. One, life estates. So what's a life estate? You own property that you own, a separate property that you own prior to your marriage with your current spouse, right? You want your spouse to be able to live in the property for as long as they want. The other one I've seen is that a parent has a child living in the home with them who's been helping as a caregiver. And, and that parent's like, I want Susie, who's been living in the home with me, be able to stay there until grandkids have graduated from school, because they've been living here. They've been going to school in the school district. I don't want them to have to move, get out. She can't afford to move to buy a house in this neighborhood. So I want her to be able to stay in the house with the kids until the grandkids are out of school. And then after that, the family can choose what to do with it. But if they sell the property, I want the proceeds divided equally among my 3 children. That's a special instruction. That's what's known as a life estate or things along that lines. That will not be used in one of these wills that I'm going to show you today. That one, you're going to have to write a different type of a will. The other type of instructions that can happen is another one that's pretty common is that someone has helped do something. So the example would be, hey, Susie, help me replace my roof. That cost $20,000. I know that we're going to sell the house, but I want Susie to get that money back. So when you sell the house, I want Susie to get the first $20,000 of the proceeds, so she gets her money back for paying off for giving me a new roof on the house. And then the rest of it gets split equally among my 3 children. Again, special instructions, and that's not going to be in these forms. You're going to need to write a different will that kind of says that. If you don't have that in there, but you want that to be the case, you are relying on your family to follow your verbal instructions, not enforceable in a court of law. And ultimately what your will says is what will govern. That's all the judge can do. Judge is going to be like, I have a will that says something different. And even though grandma may have said something different,
I can't use what she said. That doesn't have any validity in a courtroom, unfortunately, right? So just kind of be aware of that. All right. I'm not sure where we are in our forms here. Oh, I'm late. Okay. All right. So now let's talk about the sections. The will, those of you in person, you can just follow along. I know it's really hard to see the little section on the side with the parts of the will. Again, remember, they may or may not match depending on what form you have in front of you. Section 1 is your identification. It's really just filling in who you are. Your full legal name, that's your current legal name, and any other as known as names of previous names. So if you have legally changed your name, you may want to put in a prior legal name. If you also go by nicknames, you can also do that, right? So someone's nickname may be, big example is that my dad's birth name was William Campbell. He hated going by that. He started going by Glenn. And then eventually he changed his name and it became legal. But like if he had never changed his name and went by Glenn, then he would want to put down also known as Glenn, right? So a lot of people don't use their names, believe it or not. Strange. It's not strange actually, but it's kind of like, it's actually really thinking about how many cases we get like that. But anyways, but a lot of people do use different names, nicknames and things like that. Your spouse, if you're married. So if you have a form, if you're single, there's not going to be a line for a spouse. It's going to say, I'm not married. Your children is what it's going to ask you to do. But there's some little legal language in there. So they're declaring that it's your will and it's revoking any prior will. So that's what that first section is. It's just setting up who you are. And that's a will. What's not on here is that there's going to be a section for grandchildren. If the child has passed, if there's a previously deceased child, you're going to list your deceased child with the grandchildren because that's how they're going to inherit. Okay. Everything I own except specific gifts. This is what is known as a residuary clause. That's just what it's called legally. It's everything. Anything not talked about later in the will specifically is going to fall under this section. A lot of people just have just this section. There's a lot of wills that says I leave everything to my spouse. In the event my spouse predeceases me, all of my children inherit everything equally. That's actually a very, very common will. That's what these sections basically are saying, is that everything is going to one person and then the alternate beneficiaries. For those of you who are following along on a married form, the married form is going to be gift to your spouse. If your spouse does not survive, divide it equally among the children. That's option 1. Again, that's very common. I see that a lot. And this is going to be all the property you own, plus your separate property, plus your half of community property if you're married. Okay. If everything is going to your spouse, including your house, you're going to skip the next section. I'll repeat this. Then we have an option 2 for if you're married. So option 2 is, again, your separate property plus your half of community property. This one says that everything goes to the children equally. Does not matter if a spouse is survived or not. Spouse can still be living, but the children are going to inherit everything, right? Their half is going to just bypass spouse 100%. Okay. That's also very common. It's quite common when the children are from a previous relationship. So that's usually where I see the differences. But that being said, it's also not uncommon that sometimes I have older couples who come in and they're in their 70s and they're like, what's the point? Like the kids are going to get everything anyways. We might as well go ahead and give it to them now. So that way we don't have to go through, like, it's just automatic. Like it's just going to be part of the course. That's also something that's pretty common, that they just go ahead and bypass the spouse because spouse has rights to stay in the property. They still own half the property, that type of thing. There's no right or wrong here. It just really comes down to who do you want to inherit? You want your spouse to inherit everything or do you want your children to inherit everything?
I have a question. If it's previous children or previous marriage and the spouse dies and she leaves her half to her kids from a previous marriage, does the existing husband have to sell then and give them half the money?
No. So if it's community property, only the half that's owned is what got passed to the children. The other half of the spouse that survived, he still owns half of it. And he has a legal right to live in it for the rest of his life, right? Even if one has the person who co-owns the house, but also has a surviving spouse. Texas gives the surviving spouse legal right to live in any property for the rest of their life. So, now it doesn't mean that conflict doesn't happen and people try to sue, but like, that's typically what the law allows. All right.
So again, this is residuary clause. We're going to talk about specific gifts in a minute, but those are going to be the two options available when you're married. For the residuary clause, everything you own that's not specific. Now, if you're single, it's just one person. You're just listing what you want. Everyone I think I owe is going to go to these people. If you name 4 people, they're each going to get a quarter of what you owe. If you name one person, they get everything. So single people, easy, just whoever you're listing, right? And so single people with no children, right? This is what that is. All right. All right, now we're going to talk about specific gifts. So specific gifts is the actual item, the thing, the actual tangible thing that we're talking about. The section 2 was everything that you own. You can skip this section if everything you own is going to go to that person, right? Like you're like my household stuff, my jewelry, everything's going to go to my spouse. Everything's going to go to my children. The way it was in section 2, you do not have to complete section 3. Section 3 is only if you are doing something different from section 2. The person who's inheriting is different from section 2. Does that make sense? Okay. So if I don't make sense anyway, just let me know. So there's going to be 3 parts to this section 3 on specific gifts. The first one is your home, your house. Whoever you name there is going to get an equal share. You name 3 people, they're going to inherit a third of what you own. It's inherited subject to mortgages and liens. So again, they have to pay off this debt, or they have to find financing or work with the institution to assume the loan. Different things, different situations, depending on the loan, depending on the financial institution. No way for me to know what that's going to look like when it's done. But just kind of be aware of that. Okay. Now, we're going to talk about a transfer of death at the very end, but on a transfer on death deed, just so that you are aware, and I will repeat this at that point in time, a transfer on death deed trumps the will. It takes priority. So if there's a transfer on death deed filed, it does not matter when it was filed in comparison to when the will was executed. Will executed after the transfer on death deed applies. Will executed and new transfer on death deed says something different, transfer on death deed applies. It is superior document to the will when it comes to a house. So just be aware of that. So and we'll talk about a reminder of that. So if you change your mind on who's going to inherit the property and you have filed the transfer on death deed, you will need to change that. The will cannot change that. So, and this will definitely cannot change that. So, so it doesn't really matter. But so section 1 only for your house, right? And this is your house. This is your home. It's using the word home, right? This is not talking about your vacation property in Galveston. This is talking about your home, right? Your primary residence. Remember that individual plan. What property you own is going to make a difference on whether or not this will is going to work for you. Then the second section is personal and household items. So this is going to be the things in your house, your clothes, your furniture, your jewelry. That's going to be your household items. Again, this is just like the home. It's different from what you put in section 2. So section 2 is like everything's going to go to my spouse, but I want all of my personal and household goods to go to my daughter, Susan. That's right. That's what we're talking about. So after Susan takes out all of the household and personal items that belong to you, anything remaining now goes to spouse, right? So that's how this works. That's how this is working, right? So this one, again, each person that you name gets an equal share of all of the items. No specific items. This is not where you put grandma's diamond ring. This is just everything in the house, right? If anyone disagrees, so if you name through all your 3 children there and they are like disagreeing, no, I really want that quilt, the executor gets to decide who gets the quilt. Like that's what it's saying. The power of the executor to be the final decision maker in the event of a conflict. So that way you won't have to go to court to argue over grandma's quilt. Right. So executor gets to decide, which is why, again, that really important discussion to have with your executor about what you want to happen with your things. So that way they are empowered to make that decision should it arise. Right. I hate to say it, but death causes family conflict. It just does. Families get fractured by it a lot. And, you know, I don't think it's always necessarily because people are like greedy or things along that lines. I don't think that's actually really what happens. I think people are grieving, and it's a way to express that grief and anger at the loss of someone they love. And so because that's a way to kind of express that, it's also a way to gain control and power over things for themselves. I can't control my feelings, so I can control the things. So it can create conflict. And a lot of this drafting, this wills and things like that is trying to avoid creating that conflict and empowering the executor to be able to come in and serve to some degree as a mediator to prevent that conflict from happening. So just kind of be aware of that. Right. Now, in the third part of section 3 is the specific item. This is where we're going to list grandma's diamond ring, right? Grandma has 2 diamond rings. We're going to make sure we know which one we're talking about. Grandma's diamond ring with the rubies, grandma's solitaire diamond ring. Grandma's got rings, but all right. So that's going to be where you're going to put these items, and then you're going to list the person. Be sure who you list is clear. If they have similar names, be sure you add other information on that, right? So if there's a Bob Smith, and then there's Bob Smith Jr. and Bob Smith III, right? Then you're going to want to be sure you put Bob Smith III or Bob Smith born on, January 30th, 23, whatever, right? So you're going to want to be sure there's identifying information so they know exactly who it is that you're talking about there. Okay. And that's it on the gift part. That's everything on the giving part. Everything is subject to that debt. I don't cover it much here, but in my presentation in the introduction, I go really in depth into what happens with debt and mortgages and things along that lines. I don't think I have enough time to really go in too far into debt and in depth into what happens when you have debt on property. But if you have debt on property and you're wondering what that means, I do recommend you go watch that recording or come to my session in October, and then we'll be able to really talk about what happens when you have mortgages, reverse mortgages, and things like that, and how to plan for that. But that being said, it's pretty common. It's not like people don't have this happen to them. Just be aware that the family just has to figure out how to pay the mortgage, right? So, and they usually do. There usually is a plan. They know that it's there, and so they'll take care of it. Section 4 is the independent executor. Again, that executor is that person who steps into the role, who handles the paperwork, who takes care of all the probate process. They have to be at least 18 years of age, and the court must approve them. It's pretty rare for a court not to approve an executor named in a will. Things, but there's sometimes fitness, they can't be bonded. There's some trust issues and stuff like that. It used to be that if a person had a conviction for a felony, they couldn't serve as an executor. That law got changed, went into effect this year. But so there's some reasons where someone may not be able to serve as an executor, but the court does have to approve it. But for the most part, they usually approve whoever is listed. This is just maybe your first, second, and third choice. And only one person will serve at a time. Independent, what does that mean is that the court is not going to supervise the executor. This is where that well-drafted, properly executed will, when I talk about making the probate process easy, this is that language, the important language of the independent executor. What happens when it's an independent executor? You show up to court, we talk about presenting the will the way I talked about it. Fantastic. No reason why we can't appoint the executor. Executor, you're being sworn in. It's 10 minutes in court in a hearing. Sometimes in Harris County, via Zoom. Other counties can't say it's going to be via Zoom, but right now in Harris County, they're doing those in Zoom rooms. You don't even have to leave your house a lot of the times for some of this. The attorney might ask you to come into their office, but but that's it. That's the extent of the in-person court appearances. After that, the court's not going to supervise unless there's a need. Someone issues a contest. Someone's like, executor's not doing what they're supposed to be doing. Other than that, the court's going to issue papers, and the executor's going to do what they need to do. Contact a realtor, contact the bank, oh, here's grandma's diamond ring. Like, they're going to be able to do what they need to do without asking the court for any permission. Don't tell the court anything, right? We're going to talk about like one of the other things that they have to do in court because it's part of the will. But other than that, that's it. That is what an independent executor does. That's what makes it easier. That's what makes it less complicated. And then most of the time, once the executor is done doing their work, there's 2 more things that has to happen in court, but they never go back into court. It's just filed. The attorney just files the paperwork. Okay. Right. Section 4, this is where I was talking about that language, right? Without bond. So typically you can ask the court to appoint the executor with a bond. What is a bond? It's an insurance policy that if the executor should mismanage the estate, then that protects the assets for the beneficiaries, right? That's what a bond does. If you have picked an executor that you trust is going to do what you need to do, you don't need a bond. So you're going to have them serve without bond, save that money for something else other than paying for a bond. Then the powers given to the executor is to settle the estate, paying the debt, distributing the property, selling the things. They can do so without having to consult the beneficiary. So again, if there's conflict, executor has been empowered to make the decisions that need to be made according to the terms of the will. They don't have to ask for permission from somebody else. Somebody else can't fight them on that. And this independent executor that can do what they need to do without asking the court for permission for anything. The only thing the court's going to do is probate the will, that first hearing, record the will, that first hearing, notice the beneficiaries, lawyers take care of that by letter, by email, or actually by mail, and sometimes by a constable, but usually by mail. Then there is what is known as a required inventory and appraisement and list of claims. That's basically a list of the estate, what the estate owns, who owes them money, and who does the estate owe money to. That's what it is. It's an inventory that's due 9 months later. So the executor is going to take care of that with the attorney and they're going to file it. That's just something just sent to the court. And then when and that's it. Those are the powers that the court will have. That's the extent of what the court's going to do. When the probate's done, when the executor is done with all of their work, then they will file a final inventory saying, this is what happened to all the stuff. This is what I did with everything. And then the probate closes at that point in time. So literally 10 minutes in Harris County in a Zoom. And that's the extent of the probate process with this will, the way it's written. All right. Section 5 is now the children part. So if you don't have children, your copy of the will is not going to have any of this in here. But this is going to be sure that we're taking care of, actually, that's not true. You can still have this in your single one. It's quite possible because you can have an inheritance to a child. So I'm sorry, that's a lie. This one is going to be in there, but children cannot inherit property and own property. They can inherit property, but they technically can't own it until they're 18. So there is a law, Uniform Transfers to Minor Acts of Texas, that governs when minors inherit property or receive property in any sort of way. So there's rules around that. This section is basically instructing the executor to make sure that any property gifted to a minor is handled according to the laws of this, according to this transfer to owners. It's setting a custodian, it's a person who's going to be responsible for managing that property until that minor turns 21. So again, that individual plan is that's not what you want, then you're going to have to do something different. If you want that child to be able to inherit something at 18 years old, which they can do, you would have to write a will that says something different from that. You're going to, if you want the child to be 30 before they have access to it, and you want to create a trust with something like that, then you're going to want to create something different for that in a different will. You can do things, right? But if they're under 18, it does have to comply with law. So.
Let me get that straight. So you have to be 18 to inherit, but if you're not 18, then you have to have a custodian until you're 21?
The custodian can give it when they turn 18.
Oh,
Yeah,
oh,
yeah.
okay.
So, but it allows for maturity.
All right. Now this is the one that people are not going to have if they don't have children. Guardianship. If you have minor children, you have to designate a person who's going to care for your child when you're not able to do so. That is what this section is. It's an appointment for a guardian of the person. This is to care for that minor children, who's going to raise them, take them to school, that type of thing. The guardian must be approved by the court, but typically, again, short of them not being approvable, they're going to end up here. All right, section 7 is just standard legal language. It's just basically saying Texas law applies. Texas law is only going to apply in Texas, right? So if you own property in New Orleans, Louisiana law is going to cover that. You have to look at Louisiana inheritance laws and things like that to be able to figure out what to do. It doesn't mean that you can't have a will in Texas that says you can do something like that, but that will in Texas must meet whatever Louisiana's laws are, right? So just be aware, it's only Texas law, things in Texas that apply. So, but that's basically what it's saying, is that the Texas law would apply. It also has a right, a survivorship clause. So what is a survivorship clause? It's basically saying a person has to live at least 30 days, and that's what this one's saying, it's 30 days. If a person doesn't live 30 days, then they're going to be treated as if though they passed away before this person in the will, the testator, the one who wrote the will. That means it just automatically goes to the alternates, right? So this kind of is like planning for potential people passing at the same time, right? So I just recently rewatched Star Wars, but like when Carrie Fisher passed away and her mother, Debbie Reynolds, passed away the next day, right? Which was horrifyingly sad. But like but Debbie Reynolds, if Debbie Reynolds was an heir under Carrie Fisher's will, the probate court would have interpreted as Debbie having passed before Carrie, and the will wouldn't apply that way. So that's basically how survivorship clauses work. It's just kind of making sure that it's avoiding multiple probates in the event for the possibility that people pass away in time close to each other. It's not, it's accidents, like people in car accidents together, and things like that. It's grim. Sorry, it's a downer talking about this sometimes. Then here we are on the execution side of things. So you're going to complete this information. You're not going to sign here. You're just putting in the information for who your testator is and your two witnesses. This is an attested will. This is a typed will. You must have two witnesses sign this will for this to be a valid will. So, and that's where you're just going to include names in that section. All right. Then with a notary present, you're not going to sign anything without the notary present, right? This is how you make this a self-proving will, is that you need the notary present there. Because remember, self-proving allows you to admit the will without having any witnesses. So you want to be sure that this part is executed correctly. There's a whole section that kind of declares that this is a will, that you're executing it, and that you're doing it with the witnesses, and that you intend this to be your last will, right? So you're going to sign it. The witnesses are going to sign it. I don't have screenshots of all of it. It's like 3 pages. The witnesses is going to sign it, and then the notary will complete the process. The notary has a script. So the very last page of these documents has the script that the notary has to follow, which is basically getting the witnesses and the person who's writing the will to swear certain information, right? And then they're going to go through these questions, and then the answer is satisfactory, yes, 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 to most of them. Then the notary will sign and affix the notary seal to the will. Really important to know, not all notaries will execute a will. So you can't go to your UPS store and expect that notary to execute a will. A lot of notaries don't feel comfortable doing it. So they prefer not to do it. Your bank notary may or may not, depends on the bank. Some of them will do it if they actually have like advanced planning bankers, so like planners there. Some of them won't. Like I bank at Wells Fargo, my bank won't do it. So it's my local bank. I'm sure there's a bank somewhere in Wells Fargo that'll do it, but not my bank. And so so just kind of be aware of that. Now, that being said, Ms. Nia with NRCDC, they do actually have, once a month, we do have they have a session where you can come in for those people who drafted their own documents, as long as you, and they will have a notary there that can help execute these wills. We are also going to be having a secondary in-person day, even whether you're here in person or on Zoom. We will have another in-person day on September 24th, where it's at 10 a.m. and where if you have drafted your own documents, we will have individuals here that can help you review your documents and or execute your documents at that stage, at that time as well. So if you're drafting your own documents. Okay. So what to do? From 10 to noon.
Where? I'm sorry?
So what do you do next? You're going to staple the will. By the way, after all, you printed it out, you're not going to staple the will until after you execute it, right? After you sign and date it. Then you're going to staple it. This is really important to remember. Do not ever, for all infinity, unstaple it. So that, believe it or not, can be viewed as a destruction of the will, which will void
the will. Do not take it apart. So, and it's really important that your executor knows that, because it's, unfortunately it has happened where an executor, we're like, oh, do you have a copy of the will? Yes. And then they send us to us unstapled. That's because they've taken it apart to make a photocopy and you're like, no. So don't unstaple it. That's really important that you don't do that. You can make copies, but you should do that with the flipping it over and things along that line. So copies are not valid. You need to have the original will. The original will is what needs to be presented. There are kind of rules and workarounds to try to omit copies of wills, but those are actually kind of difficult. So better to always have a copy of always have your original will. To make sure that your executor knows where that is. Keep your will in a safe place. So what is that? Is that your safety deposit box? Maybe, maybe not. Really important to know safety deposit box. In order to get access to it without a court order, is that the person must be an account holder of the box and must also have a key. So it's not enough to just be on an account holder. If that person does not have a copy of the key, they will not be able to get into the safety deposit box. If that's the case, then you will require a court order to open up the safety deposit box, and only the person who believes that they are the executor. And if it turns out that they are not the executor, they cannot take the will out of the box. So it has to be the executor that can walk away with the original will. So there's that. So a couple of options. So what do you do with that? I don't think you need to put it in a safety deposit box. I have a safe at home that has all of my important documents, my birth certificate, social security card, passport, right? Like, where do you keep your important papers? I would put it there. Put it someplace safe where it's not easily accessible, that people can't steal it or you can lose it. You know, you can easily grab it if you need to in the case of an emergency. That, so just keep it someplace safe like that. We literally have all of ours in a little baby safe in our office closet at home.
What about giving it to the executor?
It is my personal preference to always keep your own documents. The reason why is because you don't want to give your original copy to your executor, because what if you change your will, right? And not to say, I mean, in theory, if you do a new will, that's supposed to revoke the original will that your executor may have. However, doesn't mean that there won't be conflict potentially. So I always recommend that people always keep keep their original documents and give copies to other people. Some other options that you consider, you can record your will. What does that mean? You can send it to the county clerk where you reside, and they will do a recording of the will. They will send you back your original will, but there will be what is known as a recorded copy, a copy at the county clerk's, and that can be viewed just as good as the original, should the original get misplaced for any reason. But that's another place you can do it. Not required, that's not part of the process, but you can do it if you want.
And it doesn't become public information.
Huh?
It's not public.
And it's not public information. No one's gonna be able to go find your will. No, when you go to probate, the will does become public, but it's unless sealed. But yeah, no one can find your will while you're still alive. Okay. Instructions to your executor: where's the will located? Tell them not to unstaple that will. And then tell them that the executor needs to know they need to take the will to an attorney when the time comes. The will doesn't do any good if you don't do something with it, if you need to do something with it. So, and an attorney will be able to go over the will with the executor, explain what needs to happen, whether a full probate is necessary, a probate alternate or lesser court process is sufficient to be able to accomplish what needs to get done. But we won't know that until the time arrives. But they do need to talk to an attorney to be sure it happens next. Okay. All right, I'm about to switch to transfer on death deeds at this point. I'm looking at my time. Oh, we're doing good on time. So let me take a sip. All right. So a transfer on death deed is something else that you should consider doing. Just like anything else that I talked about, you need to think about whether or not this is the right document for you, right? So a TOD is a fantastic way to transfer property. So what it does is it's a deed. So it transfers property to a named beneficiary, and it's effective immediately upon the person's death.
What this means, though, is that it avoids the probate process altogether. So if you kind of reflect back to what I talked about earlier, which is that your non-probate assets, your bank account, which is the biggest account that most people have, that is a potential probate asset, that is a probate asset. So you make that into a non-probate asset, your payable on death account. So now you have it as a non-probate asset. That's going to pass without going to probate. Then you have your non-probate assets, your beneficiaries of your life insurance and your 401ks. You're going to make sure your beneficiary is up to date on that. That's not going to ever go into a probate court. After that, there's two things that are the biggest things that have to happen after probate for most people. Right. So first we're talking about money. Money is the biggest one, right? So bank accounts, retirement accounts, we've taken care of that with beneficiaries. The things that people own is your house and your car. After that, it's your household items. Believe it or not, you don't need to go to probate court to deal with your household items. Most of the times, the family can deal with the household items, right? They'll be like, okay, we just need access to the property. Having a copy of the will is usually sufficient. Sometimes they may require the letters to get access to an apartment, but a lot of apartment complexes, you just walk in with the will and be like, I'm the executor, I'm coming in to take the stuff, right? They're not gonna, a lot of apartment complexes don't fight that. Right, but it's the household items can usually be handled by the family. They're like, okay, you get grandma's quilt, you get the, we have the will, it says who's getting what, right? The only time that the individual items need to go to probate court typically is when there's a fight. Right? If there's instructions for an estate sale and everything is split equally among the three kids, well, then they're gonna have an estate sale and have split money equally among the three. Do you really need there's no need for a judge to be involved in that, right? So, because the will tells you what to do, you don't need a court order to have an estate sale. So, because you already have access to the personal property. I'm kind of going about this in a long way, but I just want to kind of explain, like when you're thinking about the probate process, no matter what, you're still going to need a will, like regardless of what I'm saying right now. So with your house and with your car, the state of Texas actually have documents that transfer upon death without having to go through the probate process. So if you are a person that has taken care of your cash, you're not worried about your household items, your family's not going to fight, you have a will that gives them that instruction, whether or not there's a probate. Now you have a transfer on death deed that takes care of your house. You can potentially avoid the probate process altogether. And there's, you're still going to want to talk, you're still want to have your executor go talk to an attorney, just to be sure, because debt still survives, right? We still have debt. We may need to deal with debt. But it's, but you may be able to avoid the probate process altogether with these three things. Now, for the car, there is something known as the designation of a vehicle, of a beneficiary of a motor vehicle that does exist, which is similar to a TOD, but for your car. I generally don't advise people to do that unless they know it's their final car. It's an heirloom car, like right, these collectible cars type of things, or a mobile home or an RV. Mobile homes and RVs tend to be owned for decades. And so you would use that designation of a motor vehicle beneficiary for that. I don't have that document here, but otherwise, even for that, if you don't have that, the state of Texas actually has a pretty simple process where you can do that after a person passes away. So even if you don't execute that document, you would go through this process with DMV to change the title of the property after a person passes away without having to go through the probate process. So there's ways to avoid it altogether, but there's that other form. So I'm just kind of letting you know that because this is a way to mitigate the need to go to court, which is really the biggest concern that people have. It's like, I can't even afford that $1,000 for that attorney. We don't have anything. I can't have to go through the court process because even that's not much for me or for the estate to cover, right? So just kind of be aware. Again, as a reminder, this takes priority over a will. So if you file this and you record this and you do a will that says something different for your house, that is not going to take the will's not going to have any effect. Only the TOD will. You still own the property. You can mortgage it, sell it, repair it, do whatever you want with it, rent it out. It's your house until it's not your house, right? And it's not your house according for this document and when you pass away. So it's only the portion that you own. So remember, community property, it's only your 50%. You can use this document for a couple who does own who own community property. A couple can complete a TOD together.
You're gonna see that in a minute. And then joint owners, it's just whatever you own. So if someone inherited a property and like 3 kids inherited a house, they each own a third and they do their own subsequent Todd. It'll be their third that gets inherited down. And again, just like under the will, a house inherited under a Todd is also going to be inherited subject to any debt that's owed on that property. So the pro se Todd forms, I'm going to let you know, I find the first few times that I help clients complete these, they're confusing. They're actually confusing. So don't feel bad if you look at this and you're like, I don't know what any of this is saying. I'm hoping to give you some clarity here to help you complete this process, but it actually can be pretty confusing. So follow along. There's a recording, come back to it if you have more questions. There's a paper version of it. That's been prepared by Texas Access to Justice Commission. That's available on texaslawhelp.org. You'll see the link there. Through Texas Law Help, but even that link in front, there is a form that is an interactive online form that you go through kind of an interview process. They ask you questions, you type it in, and then when you're done, it'll give you a PDF of their transfer on death deed that you will print out. So that's how you can do it on your own if you're trying to do these documents on your own. Okay. We're going to be going through the toolkit today, but just know whatever information I talk about in the toolkit will be the same as if you complete the online interview questionnaire part. Okay. So the first part, who owns the property? You're going to list all the owners. If there's more than 2, you're going to add it on a sheet of paper to the document. You're going to be like, see attached additional co-owners, right, on the property. But you must name all of the owners listed who own the property. Pretty simple. It's your mailing address where you live and where you receive your mail. Okay. This is probably the hardest part of the Todd, and this is where it can invalidate a Todd most likely. You need your legal description of your property. That is not your mailing or physical address. Your legal description of your property is that Lot B, Section 3, meets and bounds, that language that you see in your original deed. So you need to get a copy of your original deed, your warranty deed, quitclaim deed, whatever it is, that has the legal description of the property written there. And you're going to want to type that into this section exactly the same as what it is on your deed. How do you find your deed if you don't have your deed? It is at the county clerk. You can request a copy of your deed at the county clerks. They do charge you if you request one for it, but that's where you can get one. You can also come to someone like us and we can look it up for you. We have access to it. It is public information, like people can find it and do that. Know that it's not the description on your tax property statement. So that will have what looks like a legal description in that description, but that's truncated. It's a shortened version of what it is. It's just enough to be able to identify your property to the property tax account, but it's not the legal description of the property. So remember, it's what you need on your deed. If you can't find it, people can help find. And I'm hoping that the county clerk's going to be there on that Tuesday, and maybe they can help do it that way. If not, we can work on that maybe. So then the address of the property is separate. That's the physical address. That's going to be the mailing address, the actual location that people know. So 123 8th Street, right? That will be the address. Okay, but it is the legal description is the biggest area of mistakes that I see from people who are trying to do this document by themselves. And I've talked to other attorneys who've done it, and we feel like that is the area. That's the area and it's hard. Like it actually is hard. Like sometimes you don't know what you're looking for. Sometimes I've seen legal descriptions that are 2 pages long. Like they're sometimes they're tough. So all right. Now we're going to start getting into what looks like it's complicated. And this is where I hope I make it a little simple for you. There's going to be 3 sections, an A, B, and a C, okay, in the toolkit. You are completing one of those. You're completing either A or B or C. If you complete A, you're not going to do B or C. You do C, no A or B, right? It's only one of those sections. Section A is when both spouses own the property and want to leave it to their surviving spouse. So that's what this is going to say. So, right. So number 1 is that my spouse is the primary beneficiary. They're going to inherit the property after my passing. And then upon their passing,
it's going to go to the alternate beneficiaries listed. So that is actually what it's saying. It is not creating a life estate, but essentially that's what it's doing. It's a couple that's agreeing as a couple that their property is going to pass to the other, and then upon the passing of the second, it's going to go to the children. That's typically what this is. So that's how you're going to pick A, right? So that's limited. That's actually pretty limited, right? It's only not, it's a lot of people, but not everybody. Yeah. And then for B, it's also married, but one spouse owns the property. So this is separate property. They own the property prior to the marriage, and now they have a spouse. The spouse is the primary beneficiary. They're going to inherit the property completely. If the spouse passes away first, then it's going to go to the beneficiaries. But but in this situation for B, if it goes to the spouse and the spouse has survived, it is now the spouse's property. The beneficiaries will no longer, the alternate beneficiaries will no longer be an option, right? Just want to be sure that's clear. A, it goes to the children after the passing of the second spouse, the one that survives. In B, spouse survives, it's going to go according to their will, their transfer on death deed that they file later on. These alternate beneficiaries will never inherit the property if a spouse survives and inherits under section B.
I'm gonna play Myra here for a minute. So in that regards, if spouse then remarries, the spouse can then give your house to his.
Exactly. Exactly.
Mm.
So if that is not what you want, do not pick B. It's a joke. Like, what was it called? Who do we call her? Barbara.
Barbara.
So we have an imaginary Barbara. Apologies for anybody whose name is Barbara, but we had an imaginary Barbara where surviving husband has married Barbara, and Barbara's not going to hit your house. So if that is not what, but so again, or if that surviving spouse has children from a previous relationship, his children are going to inherit the property, not your children, right? So this is a very, this one, I don't know, a lot of people don't pick this, but it's like, because it's not really what they want. But just be aware that that is how this is written, is that it's going to go to the spouse. It's now theirs. If the spouse is predeceased, so you are now a widow or a widower, then it's going to go to the named alternate beneficiaries because there's no surviving spouse. So just kind of be aware of that. And that's how that's how this section works. Again, it took me a minute to figure out what was happening here. And I was just like, because the way it's written. So for both A and B, the section looks exactly the same, which is the conveyance. So it says transfer on death, but really that's just conveying, saying, hey, we're conveying this property upon my passing. And then you're going to name what happens if one of the alternate beneficiary also has passed. So, right, there's a primary beneficiary, it's going to pass that way. So this is basically saying, like, hey, what happens if an alternate beneficiary has passed away? And that's usually a child or a sibling of the person who wrote this, is that how do you want it to go? Do you want it to go to that child's children, your grandchildren? Basically, that's what it's saying, right? You wanted to go ahead and get it passed to the grandchildren. But if that person has passed away prior to that, then no one else. This document does not exist, right? So basically, let's kind of walk through this process using option A, because that's the most common option, right? So option A, spouse has passed away. So now it's the widower who has survived. The alternate beneficiary, they had one child, and that child has also sadly passed. And so widower has now has lost their only child. If only child has two grandchildren, option A means that the share that would have gone to the grandchild, the child that, if that child had survived, is now going to go to the grandchildren equally, 50% to the two kids. That's option A. Option B is nope. Since child has passed away, I don't care that there's grandchildren, no one's inheriting the property. The TOD is no longer valid. The property is going to pass according to the will. Okay. Hope that makes sense. Okay. But that's for section A and B. Section C, completely different than section C. All right. Now again, section C, everyone else. This is anybody else. And this is where you're going to put, if you're going to pick somebody else, you want your children to inherit, not your spouse. This is where it's going to be completely different. And I know it looks like it's other because the way that people read this is that they think if they're married, they have to pick either A or B. No, if you do not want your spouse to be your heir and a transfer on death deed, you're going to pick C. So C is an option, even if you are married, because that's the other question. It's like, but I thought I had to pick either A or B because I'm married. No, that's not the case. You're going to pick C if you want something different from A or B. So that's everybody else. And that is going to be, you're going to list your primary beneficiary. You want your children to be your primary beneficiary. They're going to list that in number 1. Right, and then you're going to list number 2 has your alternate beneficiaries there. Are you stretching? You have a question? Oh.
And their, the deed is still in both their names, but they're no longer together. However, let's say with the person taxes and the property, the person chooses to. I'm thinking, I'm trying to ask the questions, but I'm thinking I'll answer too, but it's just a married couple, but an ex-married couple, the house is still in both their names. So they didn't split the property.
So the divorce decree is silent.
Yeah.
We're going to start going into the ways of family law at that point in time. And that's not my specialty area, but generally if the property was owned as community property after the separation, assuming it was equal, there's going to be an assumption of equal division, then 50% of that property belongs to each one of them. And it starts to get messy. If y'all have property in a divorce decree and it's not mentioned in a divorce decree, get that fixed. But it's not uncommon. It's more common that it is in the divorce decree, but they didn't do the work they needed to do to actually update the records. The divorce decree will still govern on who owns the property. Like that doesn't go away just because the attorney didn't finish filing and do the deed updates and stuff. All right. So now back to section C. So again, I'm going to do my best here. Oh, you're going to name I didn't realize I had done that. Okay, here we go. All right. 3 categories here under section C for what happens when when beneficiaries have passed away. Now we're looking at who's going to inherit. So bear with me. So remember, there's 2 A, B's, and C's. The big sections, married to spouse, but not to children, right? A and B and C, right? Those big sections. Under section C, there's also an A, B, and C. That first A, B, and C, picking one. 1A, 1B, or 1C. Under the A, B, and C, under section C, you must pick something in all 3, in all A, B, and C. I really wish they had used proper Roman numeral things here, because that would have made it a little bit easier. It would have been easier to be able to say little a, little b, right? So now under section C, you're going to have to complete one in the A, B, and C that's under that section C. So this is, again, I think the form's a little confusing. You just got to really read the instructions. So for A, if the primary beneficiary is a child or a sibling, and one, so you have 2, so assume it's 2, right? You have one of those primary beneficiaries has passed away. It's the same thing as what I asked, like in the first one, who do you want to inherit? Do you want the children to inherit, the descendants to inherit, or no one at all? So this is where it's going to get a little bit strange. If you say no one, Todd is still valid, still a valid Todd. But instead of the grandchildren of the deceased child getting the property, it's the surviving sibling that gets the entire property. So, right. So let me walk through that again. In this particular case, you have named your 2 children as your primary beneficiary. One of those children has sadly passed away prior to your passing, and they have 2 grandchildren. Section A, if you pick A, what will happen to the property? 50% will go to the surviving child, And then each grandchild is going to get 25%, right? Half of the 50% that would have gone to their parent. If you pick B for A, if you pick B, you now have a deceased child. The surviving child is going to get 100% of the property. Nothing goes to the grandkids. That's how Section A is written. Okay. Section B, if no beneficiary survives, that is actually what's going to look like when I talked about the one for A and B. So there's no primary beneficiary. Both children have passed, sadly. Both children has passed. There's 2 grandchildren from the first one, and then 1 grandchild from the second child. So there's 3 grandchildren. They do not inherit equally. The 2 grandchildren of sibling 1 gets 50%, 25% each, 25% each. Sibling of a child of second sibling inherits 50%, right? They get their respective parents here. Okay. So that is when you pick A. B is that there's no alternate, if there's no primary. Remember, let's go back up. You see number 2 there under C, there's alternate beneficiaries listed there, right? So under B, if you say either to the descendants of the deceased primaries or according to my alternate beneficiaries. So if you wanted it to go to your sibling rather than to your grandkids, you would list your alternate beneficiaries there as your sibling. And then under B, if both the kids pass, it would go to your brother. Does it make sense? Okay. And then, of course, in Section C, if an alternate beneficiary doesn't survive. So right now you have primary beneficiaries who haven't survived, alternate beneficiaries haven't survived. Now what? Like right now who? So it's like, it's planning for all the worst case scenarios, right? Like there's there's always like one cabinet member that never shows up to the State of the Union address, right? Just in case. This is right, their worst case scenario happening here. This is if no alternate beneficiary has survived, who do you want it to go to? Now it's going to go to the alternate beneficiaries and heirs. And if you say no to no one else, now the Todd's invalid, it's going to pass according to the will. This can get complicated. This can really actually get complicated when you're using this form, which is why it's one of those like this, sometimes for Section C, none of this matches what you want. Like sometimes people are like, well, no, that's really not what I want. You can write a complicated Todd. It's just that this Todd may not be the one that's going to serve your purpose. So. Future it's at the time of passing. So you can have, because the alternates are your descendants, right? So you can't put future, like you can't be like, I want my alternate beneficiary to be any potential future child that doesn't exist. It does have to be a person, when you're completing a name person, a beneficiary, it does have to be someone who exists. But the alternates, the ones like, who do you want to get it if the event that the person passes, that can be someone who's later born. It's their descendants, their heirs, right? Okay. So, all right. Remember, we have help. So, and I'll talk again. I'll remind everyone about that help coming. So what do you do next with a Todd? You do need a notary present. You're going to sign the Todd with the co-owner if it's applicable. Again, if there's joint owners and they're doing that joint thing, you need the co-owner there to do at the same time. Notary is going to sign and affects their notary seal. It's nothing special. They're just watching you sign it and doing all their good stuff. You must record the Todd. What does that mean? You must send it to the county clerk where the property is located. The county clerk is going to stamp it as being, yes, I received it. They're going to return the original deed back to you. And now there is a written record at the county clerk's office of the property transfer going into effect. It is not valid. If you do not file your Todd with the county clerk, it is not valid. It has no effect in law. So be sure that you do that last step. We have had people do things on their own, don't take that last step, and then they're like, well, now you have to go to probate court. That Todd doesn't serve any purpose. Okay. And that is it. Keep it in a safe place, put it with your will and your other important documents. And that is the Todd. So we have a little bit of time, not a lot, 10 minutes. I'm going to talk about a little bit about planning for incapacity. The reason why I can kind of gloss over this pretty quickly is because these documents actually are not that complicated. And here's why. So there's some additional forms. They're all available on texaslawhelp.org. When you get the email from us, you will also get copies of this as well. The reason why these are not complicated is because they're statutory forms for most of it. What is a statutory form? Our folks in Austin has told us what the form has to say. We don't have to write anything. It's already written for us. We just have to decide what we want to include, has our powers in that. And that's just really up to you. It's deciding what kind of powers you want the individual to have, when you want the document to be effective, and that's really it. And so you don't have to write anything new. Unlike a will where you need to kind of write, you may have to write a will, and your pro se forms may not work for you. The Todd pro se form may or may not work for you. You may have to write a Todd, right? These forms, my forms that I complete for you, look exactly the same as what you see on Texas Law Help. It's just the difference is how it prints, right? It's just the difference. I don't have fill in the blank forms. My forms are written. But that's the good news. So you can find these. That's your statutory durable power of attorney. That's when you're incapacitated, no longer able to make decisions for yourself, or because you just want someone to help you. And that is to help make legal and financial decisions in the event of incapacity. Medical power of attorney is a power of attorney. It's for medical decisions. It is always only effective when the person is incapacitated, because as long as you are able and conscious and able to make your own medical decisions, obviously you're making your own medical decisions, right? No one's going to be able to substitute in at that point in time. An advance directive to a physician is commonly known as a living will. That is end of life decision making in the event of two situations. One is an irreversible condition. Think of a coma. This is a person who is not going to pass away, but if you don't intervene with life-sustaining treatment, they will. A coma, you can live in a coma for decades, right? But you got to be fed, right? Someone needs to intervene. And then, of course, there is the other situation, which is a terminal condition, which is that a person is expected to pass away even with life-sustaining treatment. Think of like stage 4 pancreatic cancer. And then that's instructions of, do you want to have life-sustaining treatments in either situation, and or do you want to be allowed to pass peacefully? And I do talk about this more detail in my other presentation, but just so that you know what the advance directive is. But that's the decision. Again, that's statutory. The language is already written. You just have to decide what you want. Declaration for mental health treatment. This is for psychiatric care. This is for individuals who are at risk for being hospitalized for psychiatric needs. And so an example of that, someone with schizophrenia, if they're on the medication, they're fine, they're doing okay. But if they get off their medication, there's a possibility they may need to get hospitalized. And then once they're hospitalized, this document provides instructions on what kind of medical care they would like to have when they're not able to say so, right? While they're getting back into capacity, basically. Really, really important and useful documents for people who need it. So whether or not you need it, be aware of it, because if you ever encounter someone who does need it and they don't know it exists, it's a really good thing for them to have. The other documents is not statutory, but they're easy. They're actually really easy documents. Declaration for a guardian in the event of later incapacity. This is, again, incapacity, same thing, medical, legal, financial decisions, but we're talking about a permanent incapacity at this point in time. A guardianship is now needed. This document is saying who you want to serve as your guardian or who you do not want to serve as your guardian. That form is also available on Texas Law Help. You'll look at it. It's so simple. It's literally 6 sentences and that's it. It's super easy. It's so easy to do. A HIPAA release, allowing hospitals and any other organizations that are subject to HIPAA protecting medical information. You need to do that for your medical power of attorney and your guardian, so that way they can receive medical information as they need it. The decision-making document is another one that you can do. Again, that's pretty standard, really, type of thing. I talk a lot about what each of these documents really do in my other presentation. So if you want to hear more about that, we can definitely talk about that at that time. Right. Remember, eligible clients may receive free legal assistance. For those of you who are here in person and you wish to apply for services, I do have a team here that can do that today. You can also call us on the phone or go to our website, which is lonestarlegalaid.org. And that's just me, by the way. We do have two other legal partners in our partnership, which is Houston Volunteer Lawyers and Earl Carl Institute. They also help prepare estate planning documents. And so you can definitely also reach out to them. And apply for services through that. But if you like me and you want to see me, I'm Lone Star Legal Aid. And then now just to be aware of our help day, our in-person pro se assistance day. Again, pro se, you're doing things on your own. You just need some help doing getting at your documents, getting them executed. That's going to be on September 24th from 10 to noon at Sunnyside Multi-Service Center. You will be there. Just to let you know, for me, you must be financially eligible for me to provide you advice, which means that you do need to go through the application process before I can look at your documents and tell you that they're prepared correctly, help you make corrections, that type of thing. So if you would like me to be able to do that, or if I have other attorneys with me, for one of my other attorneys to be able to do that for you, please do speak with my staff or get our card and do that application prior to showing up. It saves just a lot of time. But we'll be able to do it that day as well too. So sometimes you may be like, I think I'm okay. And then you don't apply and you're like, oh shoot, I can't. Oh, that's right. Miss Jessie said I can show up at Sunnyside today. I'll bring my papers to Sunnyside. We can do the application that day too. I do see there's a question about whether or not the TOD is public records after they are filed with the county. They are. All real property is public record. That's it. Questions? As soon as it's received. Yeah. So in terms of the question being like, how quickly does as soon as the clerk receives it and they stamp it. I will say if anyone's worried about prognosis, they're like doing it kind of on, you can file them in person. And the person who, and by the way, it doesn't have to be the person who executed it. So in terms of like, sadly, there are sometimes bedside documents being prepared. Someone can drive down in person to the county clerk's office and file it. And in that way. The question was, when does the TOD become effective? And it's upon when the clerk receives it. And so if you mail it, however long it takes for them to receive it and process it, but you can walk down and walk in person and it will be recorded the day you are in line in person. If there's a concern for that, that should be someone's job, right? It's like, we've executed, now someone please go from bedside to the clerk's office. The good news is that usually the real property clerk's line is pretty short when it's not the downtown office. So.
The downtown office is not that bad. It's just the parking to get into.
Yeah, and you can go to any of the county clerk's locations. You don't have to go to the one that's nearest to you. You can go to the one that's nearest to your office or whatever, right? Okay. Well, I need a little bit more context, but in general, without going in, what happens if there's more money owed, there's more debt than what's in the estate? That is what is known as an insolvent estate. What happens is that according to the law on probate and priority, it's what it's called priorities of claims. And basically what it is that the law outlines who gets the first bite of the apple, so to speak, right? The priority claims are always going to be funeral expenses first, and then like any reimbursement that the executor had to spend out in order to be able to maintain the estate. So like if the executor is paying for the mortgage, while they're going through the process until they transfer the property, they're going to get reimbursed the money that they spent on paying the mortgage. And
And then it's going to go to secure creditors. So the person who owns the bank that owns the house until the mortgage is paid, the car, they're going to get paid second. And then whatever remains goes to the unsecured creditors. And then there's something known as a priority of claims. It's kind of like who gets what. They kind of separate out the percentages at that point in time. Like, it's like, well, you get 5%. And then sometimes if there's nothing left, you basically just tell the creditors, there's nothing in the estate. We can't pay for anything. But that is something that's kind of you have to kind of be in the situation. You have to know who the creditors are, how much money is in the estate. That's something that the attorney helping the executor will be able to kind of sort out.
And if I already filed a time, do I still need to do it?
Yes, yes. If you file a TOD, do you need a will? Yes, because no matter what, you need a will. I'm putting what if you have an unknown life insurance policy? Believe it or not, that happens a lot more frequently than you think it does. But it's, yeah, no, it's better to have a will and not need one, and need a will and not have it. It's, there's a form available. Like, even if it's not the perfect form for you, if you're like, I don't know if I really need anything, do a simple will that use one of these pro se forms just to have one, just in case you need it. Didn't hear you.
A living trust.
Uh-huh.
What does that become?
So we didn't talk about trusts today because it's outside the scope of today's presentation. I do cover it pretty briefly in my other presentation. Yes. The question always is, when you're looking at your estate planning, what is your goal? What are you trying to accomplish with your property at the end? And so when it comes to trust, that's what I usually ask. If the goal is to avoid probate, what it is about probate that you're trying to avoid. High asset estates usually have trusts as part of their estate planning. Some people need trust because minors are inheriting the property. There's reasons to have trust, but if the only reason is to avoid probate, I don't know if that's a good reason to have a trust. So the question ultimately is, what is it you're trying to accomplish? But I think if you're a person who thinks you may need a trust, you should talk to an attorney about it. Creating a trust are not necessarily less expensive than a probate, by the way, because all you're doing is shifting costs. Shifting the cost of the probate to creating the trust at the front end. You're still paying an attorney to do it, right? As opposed to paying for an attorney to do the probate. So it's, and sometimes the trust itself can be more expensive than the probate would be if you had just gone through a probate. So I would say, what's your goal? And then talk to an attorney about that and see if a trust really works. Sometimes you do need ones. I'm not saying trusts are bad, but it does just depend a lot on the individual situation.
The other question that was on here was about family guardianship, and you absolutely answered that question.
Okay.
Email to.
Campbell, like the soup.
You know, this is a question.
We are on Zoom still, so just be aware. Yeah, yeah.
I'll wait till it's out.
Okay. Sounds good. All right. Well, thank you so much, everybody. Again, the recording will be available. I know it was a lot. Please go back and rewatch the recording if you are trying to draft these documents on yourself. Otherwise, hopefully we'll see you on the 24th.
I will be sending out a report of all the
Mm.